5 seconds to go. Start. Leave granted. The present appeal is preferred for assailing the judgment dated 27th March 2014 passed by the Division Bench of High Court of Judicature of Andhra Pradesh at Hyderabad, whereby the Learned Division Bench allowed LPA number 47 of 2002 preferred by respondent number 1 plaintiff. The status and rank of the parties to the list is as below. Respondent number 1 plaintiff along with defendant numbers 2, 3, 4 and deceased M. Balraj Reddy had constituted a partnership firm. Defendant number 1 namely Messrs. Shivraj Reddy and Brothers, hereinafter being referred to as firm, on 15th August 1978, with its primary business being the construction of buildings on a contract basis with respect to the works of the government and municipalities. Respondent number 1 plaintiff instituted OS number 67 of 1997 seeking relief of dissolution of the firm and rendition of accounts. The learned Second Additional Chief Judge, City Civil Court, Hyderabad, hereinafter being referred to as trial court, allowed the original suit filed by respondent number 1 plaintiff and passed a decree dated 26 October 1998 declaring the firm defendant number 1 to be dissolved and directed defendant numbers 2 to 4 to tender accounts of the firm from the year 1979 onwards till October 1998 and further granted liberty to respondent number 1 plaintiff to file a separate application seeking appointment of an advocate commissioner for taking accounts of the firm and for other appropriate reliefs. Being aggrieved, the firm defendant number 1 and defendant number 2 preferred CCC appeal number 35 of 1999 before the High Court of Judicature of Andhra Pradesh at Hyderabad. Learned single judge of the High Court, wide judgment dated 19th October 2001, allowed CCC appeal number 35 of 1999 on the ground that OS number 67 of 1997 was barred by limitation as one of the partners in subsisting partnership firm Shri M. Balraj Reddy expired in 1984. Therefore, the firm stood dissolved immediately on the death of the partner. Since the original suit was filed in 1996, it was barred by limitation. Aggrieved by the decision of learned single judge, respondent number 1 plaintiff preferred LPA number 47 of 2002 before the learned division bench of the High Court, which allowed the appeal and set aside the judgment dated 19th October 2001 passed by the learned single judge in CCC appeal number 35 of 1999, observing that the plea of limitation was never raised during the pleadings in the trial court and learned single judge ought not to have dealt with that issue at all. Being aggrieved, appellants have preferred the present appeal by special leave. Learned counsel representing the appellants urged that the suit was filed by respondent number 1 plaintiff for dissolution of the defendant number 1 firm and for the rendition of accounts in the year 1996. He referred to the partnership deed dated 25th April 1978, whereby the firm defendant number 1 was constituted and urged that the partnership was a partnership at will. He drew the attention of the court to section 42 of the Partnership Act 1932, hereinafter being referred to as the Act, which reads as below. Stop.